So we'll go ahead and get started. Good afternoon, everybody. This is Chad Evans. I've got two partners of mine, Gabriel Thompson and Matthew Crumhorn today, and we're going to conduct the third installment of our webinar. Today we're going to address specifically longshore claims, some maritime and Jones Act issues. We're going to touch on those, a little bit of general liability issues, and then address some of the outstanding workers' comp issues that may be out there, as well as some of the legislation that's pending in Louisiana and some surrounding states. To get us started is Gabriel Thompson, partner with the firm, and Gabe handles predominantly longshore work nationwide. He does have opportunity to work with some state comp claims, but we're gonna leverage his expertise in longshore today. So we'll get started with Gabe. Go ahead, Gabe.
Okay, under the Longshore Act, there is the Section 20 presumption, and if they can show that conditions were right for the contracting of the COVID-19 or coronavirus, then the employer would have to come up with substantial evidence to rebut the presumption. They're going to have to show that there was some kind of prevalent outbreak at work to be able to do that, and it's just not casualty. However, the Section 20 presumption and the judiciary for the Office of Administrative Law Judge is extremely liberal, and it's going to be very easy for the claimant to satisfy that burden and have it rebutted. The best thing that can be done in longshore to try to protect the employers is to really try to identify early what is going on, where is it contracted. So what are the specific symptoms being reported, and when did they first occur? Has there been a confirmation from a medical professional that they were indeed tested positive for the coronavirus? Does the employee know how they may have come in contact with an infected person? If there's a coworker, then it's going to be harder. But it's going to really come down to experts as well. An epidemiologist, pulmonologist would be the experts that would probably be retained. The other question is, what is the name of the doctor that saw him for the treatment? And go ahead and subpoena those records to confirm that there was a positive test. And this is not just somebody that's putting you on. Now, there's been recent push by the ILA to have a presumption that if they have corona, that it was indeed caught at work. Also to cover the employees that are out for coronavirus with workers' compensation benefits. The ILA is the International Longshoremen's Association. You don't really have it very much in state comp, but most of the longshore workers are going to be unionized. So that's kind of where it leaves it for longshore. Now, there has been a bunch of recent developments with the practice for the Longshore and Harbors Workers' Compensation Act and how we're going to approach that. I'm going to show you a slideshow. So let me get that queued up for you. Okay. Is everybody able to see that? Chad, can you see that?
No, it's not showing up, Gabe.
Okay. How about now?
Yep.
Perfect. Okay. So we go to our first slide, and 3 new compensation districts have been created. They're trying to streamline all the different district offices for efficiency. There is now going to be the Eastern Compensation District that's comprised of Boston, New York, and Norfolk. The Western Compensation District, which is going to be California with Long Beach and San Francisco, as well as Seattle, Washington. And the Southern Compensation District comprised of Jacksonville, Florida, New Orleans, Louisiana, and Houston, Texas. Now, what does this mean? There's some of it's going to have no impact because it really doesn't change where the formal hearing is going to be. It's more of an internal process, and for the attorneys, it may be where we send our subpoenas. But as far as what this means for handling claims as an adjuster, you kind of know where your case is going to be. It's not going to be referred to as the same, the New Orleans district office. It's going to be the Southern Compensation District. So it'll be just a little bit of different terminology. The Defense-Based Act, offshoot of Longshore, most of the same law applies. There's just a little bit of difference. There's going to be several districts, and they're going to be assigned to those districts rather than the offices that are now in place, the Department of Labor in the different states. Now, much to everyone's dismay, the fines have increased. The Section 14G, the failure to report termination of payments, went from $292 to $297, not a big increase. The 14G penalty has to do with the filing of the LS-208. The 208 needs to be filed after the 16 days after the last payment that's made on a claim. Also, if there's any changes in how a claim is being paid, if there's a labor market survey and you've reduced payment, it needs to be filed. There's one that needs to be filed at the end when you close the case with any kind of 8I. So anytime there's a change in benefits, you want to get the LS-208 filed within 16 days. Okay, the next one is the Section 30E, payment for late payments of injury or death. The maximum penalty has increased from $24,017 to $24,441. Now this has to do with the LS-202, employer's first report of injury or occupational disease. That needs to be filed 10 days after the employer becomes aware of any injury or occupational disease. So the draconian penalty that was on the last slide is not where this all lands. It's a graduated scale, so your first report is going to be 500, your second 1,000, third 2,000, and so on and so on. Now, if you happen to have one of these issues, please try to get it to us as soon as possible. We can write a letter. It may be that it looked like it was a state workers' compensation case at first, and they applied for state comp. We can argue that no penalty should be applied, and I've been quite successful at that. Also, on some of these cases that there was just no notice on, especially like hearing loss or any other occupational diseases that has like a latency period. The date of injury might be the last date they worked for the company, and you're just now getting this through the mail. Well, if you want to grease those wheels so an automatic penalty is not going to be generated, that letter that just comes out with the computers, you want to have one of us write a letter along with the LS-202 explaining why no penalty is assessed. Otherwise, they're trying to go to a fully automated system, and that penalty letter is going to be generated. Now, this is the penalty for discrimination. It has increased, not a whole lot, but it has increased. This is for a retaliatory discharge, or you get some guy that comes in and the employer retaliates up to and says you can't work nothing but the night shift for the next 6 months. If he pursues a penalty for discrimination and is successful, the penalties have increased. Now, the one caveat to this, the carrier cannot pay for this. It has to be a penalty, it has to be paid by the employer. So even a TPA, the TPA is not going to be responsible. Okay. If you file or fail to file the 202 or the 208 untimely, you're going to get a penalty letter. When you get the penalty letter, please forward it to us, because you have to submit the payment within 30 days. Payments are not submitted to the local offices, so it's not going to be any of the districts we previously discussed. It's going to be to the Washington, D.C. office. However, let us try to take a shot at either reducing the penalty or having it completely forgiven or waived. Now, this is going to be probably mostly for attorneys to deal with, but it's nice to know that there's been some changes. They've introduced several new forms. Unfortunately, as of today, you can't click on the link for the forms at the Department of Labor's website. They've not been published yet. So you have the LS4. It's basically trying to streamline the attorney's fees that are being claimed under Section 28. Usually this is done in a formal fee petition. I like the prior fee petition because it gives us basis to object to individual fees that we might feel that are excessive, or that the work is performed before the ALJ rather than the DOL, which there's just certain requirements to the fee. Really, we're going to have to see how this works out because it's not clear yet. The LS5 is the application for special relief. If you have a condition such as a audiogram that was done at the date of hire, that could qualify for you for special relief from the fund. If you have a pre-existing condition, usually you have to have something that's limiting. The last one I was successful on, the gentleman was a paranoid schizophrenic, and that made it very difficult for him to be employed in any situation that he would have to be involved with the public. So as a longshoreman, he could do that task, but his disability increased when he was injured because he could no longer be placed in any other kind of position given his limitations from his pre-existing condition. Simply having a prior cervical injury where they recover and they go back to work with no restrictions, I would recommend filing a pro forma application to preserve the employer's ability from not having the solicitor raise the absolute bar as a defense, and so you can supplement at a later time, but it's not a slam dunk. You may have problems if that evidence doesn't become available during discovery. The commutation application comes into play. If you see one of these, please contact an attorney right away. Commutation is usually when an employer or carrier fail to pay benefits over a given period of time when you're already under a decision in order. There's an acceleration provision, and that's a situation you do not want to be in. These awards can get quite high, and you do not want to pay them all at once. You want to do everything that you can to mitigate it and reduce it. This doesn't come up very often. I've seen a few of these around the country from different programs that are basically paying the claimant while they are out of work, and the claim has not been accepted by the employer. This is the request for intervention, and now it's just being reduced to a form rather than a formal plea. And the wonderful LS8. This is, I believe, to streamline the process. Sometimes the claims examiners, there's an internal form that they use when they go through your 8I that they basically check off all the provisions that have to be in the 8I. I haven't seen this form yet, but I anticipate that it's going to be somewhat of the same, as you're going to provide all the necessary information that's already in the 8I, but in more of a consolidated one-page form, so they can just check it off and easily go through the document. It would not surprise me if they actually require the page number where the information is contained within the 8I be provided in the form. This is the stipulation approval request. This, a lot of employers do not like to settle with claimants unless there's a voluntary resignation. And in some situations, it is not practical or it's not legal to do so. In situations where there's a collective bargaining agreement, you may not be able to get a voluntary resignation, but you would like to resolve the issues that are in dispute. If you have to reduce it to a stipulation pursuant to the claimant or the claimant's counsel's request, this is the form to use. They're going to issue a compensation order with it. I'm wary of stipulating and having a compensation order issued, because usually when a compensation order is issued, interest attaches to that on any past due amounts. So to escape that, I make voluntary payments rather than going through this procedure. Okay, so the C portal is where you electronically submit all your documents, all your forms. This only applies to the Department of Labor. The Office of Many Administrative Law Judges, while in the COVID crisis, are accepting filings via email right now. They are not processing subpoenas, which is kind of slowing down the discovery process. All of the court dates through July 24th have also been continued, and they will be resetting them after that date. But this is just for the Department of Labor. However, if you want to still utilize, and that's for all your forms, if you want to file your 208, your 202, it all can be filed by C portal. However, you can still utilize regular mail, but you don't email or you don't mail it to the compensation districts, 3 that have been created. You mail everything to the central processing location, which is in Jacksonville, Florida. So all new cases may now be filed electronically via C portal. It was not the case. You either had to mail in your documents, or you used to have to send them in via fax to New York, where the cases were being created. So that's just an option. What documents can be filed? The notice of employee, the LS-201, notice of employee's injury or death. The LS-202, employer's first report of injury or occupational illness. Now that's the important form that needs to be filed within 10 days after the employer becomes aware. The claimant can file as LS-203, employee's claim for compensation, and they can file the LS-262, claim for death benefits. What is not in there, which may cause concern, is the LS 207, the notice of notice of controversion of right to compensation. To prevent any penalties, that needs to be filed within 14 days of the denial of the claim, or when you decide to controvert any portion of the claim. I like to file that with case creation documents. I would still try to do that. They may or may not let you. If they don't, I would fax it in. The necessary information to access the C portal is the case number, claimant's last name, date of birth, and date of injury. And as I already said, the other options is to fax it to the case creation site, area code 202-513-6814, or you can always still mail it to Jacksonville, Florida. And that is pretty much it for the Longshore update. We'll go ahead and turn it over to Matt or Chad.
All right. Get my stuff here. All right, folks. Well, what I've got is it's a different couple of issues. Maintenance and cure being one of them, and that pertains to Jones Act seamen, which we figured would be a good kind of dovetail from the topics that Gabe was talking about. Maintenance and cure obligations arise with COVID-19. Potentially, if someone either proven to have contracted the condition on the vessel, or here's the big difference between Jones Act liability and that in any sort of comp scheme, whether or not the symptoms manifest while in the course and scope of employment or in the service of a vessel. So this brings over a couple of different issues. You've got traditionally these gentlemen and ladies that are working on these vessels are working anywhere from a week to a month or more at a time on these boats. And then they spend anywhere from half to equal that amount of time at home. And the time frames or the temporal issues that could arise out is if the symptoms manifest themselves. Let's just assume if there's an obvious link to someone contracting it on the vessel, then you're going to be dead to rights on liability for maintenance and cure. However, there may not be a causal link between the contraction of the disease on the vessel, but you still may have the obligation to pay maintenance and cure. And the investigation will entail the same things we've talked about in the prior weeks regarding the detailed questionnaire regarding history, whereabouts, persons in contact with, so on and so forth. So what the first period of time is someone who's been at home for a period of time before going on watch, something in excess of a week. And that's when the symptoms manifest themselves. Unless there's a proven causal relationship to the vessels, those claims should be denied from the maintenance and cure standpoint. When the hitch just started, and I say just started within the first week of the hitch, and the hitch, for those of you who may not be as familiar with the terminology of the maritime related activities, hitch is the amount of time a person is working on the vessel, and they call a hitch that defined period of their voyage. And so if the hitch just started 7 or less days and the symptoms manifest themselves, it likely triggers the maintenance and cure obligation until you can establish that the symptoms manifested prior to the hitch beginning. And so someone gets on the boat, they may have been ignoring or overlooking symptoms for several days, thinking it was a cold or some other illness. And then once they got on the boat, it was determined that they at that point sought treatment because their symptoms got to the point to where they felt they needed it. And that sort of situation, that's going to be the most fact intensive investigation that needs to be done efficiently, because there is a presumption of even though it's not on the law, a presumption that the employer or the vessel owner is going to um, take care of their employees, their seamen. So very quickly, you've got to figure out how long's the guy been on the boat? Is anybody else on the boat positive? Has he been around anybody else? What was he doing during his time off? Where did he go? Who was he with? Those same issues that we talked about before. The next period of time is someone who contracts, or I shouldn't say contracts, someone who develops symptoms or the symptoms manifest well into their hitch, beyond a week, 2 weeks or more, definitely. At that point, maintenance and cure has certainly triggered that obligation. And um, there's likely not going to be any argument that they contracted it somewhere else. Certainly, it would be reasonable to conduct the same investigation, but it's going to become more remote of a possibility that we're going to be able to establish that his symptoms truly manifested themselves prior to his hitch. Questioning the crew is going to be important as part of this. What was this person doing? What sort of symptoms did he was he showing? Did he tell anybody anything? Things of that nature. And the last period of time is someone who had just gotten off the boat. If someone gets off the boat, whether their hitch is a week, 2 weeks, 4 weeks, 2 months, and that is when they're first reporting symptoms, maintenance and cure should not be immediately picked up unless they can establish that those symptoms predated the end of their hitch. Because the opposite applies. If it doesn't manifest itself within the course and scope of his employment in the service of a vessel, then it doesn't trigger maintenance and cure. Nevertheless, there is a possibility of them triggering the maintenance and cure obligation through causally relating their symptoms to something on the boat, and that would likely require them to show that someone else on the boat or someone they came in contact with had the disease and that they came into close proximity enough to contract it. There has not been any case law out there talking about presumptions yet. It's certainly too early to talk about that or to address that for it running its course through the court system. But those are things to keep in mind. Maintenance and cure, for those of you who may not be familiar with the term, is essentially the equivalent of a workers' comp type scheme benefits. It is maintenance, which is now it's a varying amount. It really pertains to the individual's cost of living, but it's to provide room and board for the employee while they're in their recovery period. So, now we've got clients that pay anywhere from $40 to $75 a day. That's the way it's calculated on a per diem rate. And then cure being all reasonable and medical necessary treatment that relates to this particular condition. Those amounts, those benefits are contractual in nature. They are not comp-based, although they give the appearance of being comp-based, and through the way of having the presumption of liability and the fact that no fault is required on the part of the employer. There is no requirement for the employee to establish liability or negligence to be entitled to maintenance and cure. It is a matter of right. Do someone who is injured on a boat or manifests symptoms through illness or injury while on a boat in its service. One of the defenses, which is also very comp-like, is the McCorpin defense. The McCorpin case is the seminal case that talks about people with pre-existing medical conditions that conceal those from its employer through the course of the hire-on process. The McCorpin defense, if someone being the employee violates his or her obligation to disclose prior medical conditions or history to the employer, then they could forfeit their right to maintenance and cure. It's a defense to maintenance and cure on behalf of the employer. There may still be liability for negligence, such like and other allegations of that and tort, but the maintenance and cure obligation could be avoided. Why does that matter here? Well, as we've known through all the literature, things like diabetes and high blood pressure and obesity and cardiac disease and so on and so forth, all of these conditions are considered to be high risk factors for COVID-19. If someone has those conditions and fails to disclose them and they contract COVID-19 and their symptoms manifest while on the vessel, or they contract while on the vessel, the McCorpin defense could allow the employer, the vessel owner, to circumvent its obligation for maintenance and cure. Maintenance and cure is only owed through maximum medical improvement. It is not owed beyond that. It is not owed until someone is completely cured. It is maximum medical improvement is a medical determination. It is not a legal one. And generally, it is determined to be that point in which an individual is determined to be unlikely to get any better. So any sort of palliative care, long-term pain management, things of that nature will consider to be beyond the MMI point. But once MMI is triggered by a physician, then the maintenance and cure obligation ceases. In this case, with regard to COVID, it's particularly interesting because these cases don't seem to be, or this condition doesn't seem to be which that has a long lifespan. It runs its course in one way or the other, and anywhere from a couple of weeks to a couple of months. I think in the majority of these cases, almost the entirety of these cases, the MMI determination will be less than 3 months after contraction. The thing that can keep in mind is the pre-existing comorbidities and conditions need to be considered. If someone has pre-existing diabetes and someone has pre-existing hypertension or obesity, you don't buy the responsibility through their contraction of COVID-19 to cure them of those conditions. It's returning them to the condition that they were in immediately prior to contraction. So moving on to the next issue is limited liability and immunity for businesses. There has been no law in Louisiana passed yet. In most other states that I've reviewed, there appears to be legislation pending, but nothing that has yet been placed in law with regard to limited liability and or immunity from tort exposure for businesses that have been open or will be attempting to open as part of the resumption of commercial activity. There does appear to be a distinction in the majority of jurisdictions between what is considered to be essential and non-essential businesses. Essential they vary state by state. In Louisiana, it is medical personnel, healthcare providers, first responders, restaurants, grocery stores, delivery services, and the list is pretty extensive. If you don't qualify if you as an entity do not qualify as an essential business, then you're going to be held to a higher standard than those essential businesses for purposes of protecting third parties. The reason I'm not specifically talking about employees is because that's going to fall under comp more likely than not. As we've talked about in the previous weeks, there is legislation that is removing the gray area within the law in Louisiana about whether or not COVID-19 should qualify as an occupational disease under the Comp Act. Obviously, if it does, or once it does, and I believe it will at some point, that will provide tort immunity to those employers against claims from those employees arising out of COVID-19 contractions. So it'll be interesting to see, and something to keep an eye on a state-by-state basis, to see whether or not there is limited liability or immunity for these entities in conducting their business activities. The difference there is that immunity says exactly what it sounds like. You cannot be liable for someone's contraction of COVID-19 due to their interaction with your business or work with your business. Limited liability is somewhat more restrictive protection for the businesses. And what that appears to include or involve are requirements for the employers or the entities, sorry, those business entities, to comply with whatever the safeguards that are being recommended by the CDC or the state health department or the governor's office in that particular state, as long as they're in compliance with those recommendations or orders, they're going to have limited immunity in those situations. If they run afoul of those recommendations, then they could still be on the hook for liability for someone's contraction of COVID-19. I've seen others that say it's a limited immunity, and that they're providing immunity to entities outside of gross negligence. So it'll be interesting to see how all of these states come down. When I was looking at pending legislation nationwide in the states, there are 38 states, which I'll go through here in a second, of 38 of the 50 states, in addition to Guam, Puerto Rico, and DC. All of them have some sort of liability protection, at least in the works in legislature. At this point, half of the United States are at least partially open for some level of business as of yesterday, May 4th. In Louisiana, the stay-at-home order has been extended through May 15th, 2020. The one little caveat that has changed is that restaurants can now open outdoor seating areas, although they cannot provide table service, and churches or other places of worship can hold outdoor services as long as the social distancing of 6 feet is acknowledged and abided by. For those of you who may not be aware, the White House did issue guidelines about reopening of each state's economies, and this is to provide guides, and it's up to each individual state to dictate how they're going to implement these phases or progressions. Phase 1, which the state of Louisiana has not yet entered, the anticipation is that it will begin after May 15th, because they haven't said, and I say after 15th because the stay-at-home order has been extended through May 5th. I'm sorry, I say April, through May 15th. The stay-at-home order has been extended through May 15th, which is a Friday. So technically beginning that Saturday the 16th, phase 1, assuming there's not another extension, is anticipated to begin. And what does that mean? That means it's going to keep social gatherings still limited to 10 people, but it allows restaurants, movie theaters, churches, and gyms to reopen with strict physical distancing protocols. And elective procedures can resume. That's already started in the state of Louisiana. Phase 2 is going to allow for gatherings up to 50 people, also allow for schools to reopen. Bars can reopen with limited standing room occupancy. And then phase 3 will allow everyone to return to work and visitors at hospitals and senior living facilities. I do not personally anticipate there being any less than 2 weeks to 3 weeks between each phase progression. Phase 1, it's going to be interesting. It only specifically talks about social gatherings. So it's going to be interesting to see in the state of Louisiana if the governor specifically addresses places of employment, commercial settings, whether or not those areas are also limited to 10 people. Because under the stay-at-home order, it's not just limited to social gatherings, it's also limited to the workplace. It's our understanding that Louisiana's Governor Edwards, intends to make his announcement regarding moving phase 1 by no later than May 11th, which will be this coming Monday. There's also, as of yesterday, the governor's office has begun a website or launched a website, opensafely.la.gov, which is supposed to provide question and answers and assistance and direction to employers attempting to reopen as part of the progression into a wide open economy. Once again, I tried it this morning. It is not yet operational, but that is something to keep in mind for those employers that are on the call moving forward. I think that's going to be a extremely valuable resource. There are a couple of Louisiana specific bills in place. I say a couple. There's 3 for workers' comp, and then 4 we've got, or sorry, 3 we've got for limited liability protection. As far as workers' comp go, the House Bill 1 pertains to vocational rehabilitation. It changes some language and timeframes for retraining and education. It's allowing for the retraining and education up to 52 weeks with some additional time at the discretion of the judge. And it provides employees an avenue to dispute the use of employers' choice of vocational rehabilitation counselor and obtain their own choice. It's interesting that this is now hitting the legislation or hitting the legislature in this time of crisis. Otherwise, so it appear to be the leveraging on the part of some of our lawmakers. Another issue is employees who report an accident or unsafe working conditions shall not be subject to reprisal or threat of reprisal, which includes reporting of illegal immigrant status. Again, this is something where they're leveraging the COVID-19 reporting conditions into something additional here being immigration. And then the last thing for comp, which is in a proposed bill, is with regard to independent medical examinations. This proposed bill would take the appointments of the IMEs outside of the Office of Workers' Compensation Administration hands and would place it solely in the hands of the judges, even if no 1008 is filed. I will tell you from my standpoint, this would be fantastic because it would streamline the process. The judges do not want to make medical determinations. They are going to be far more inclined to assign IMEs than the Medical Services Division of the Office of Workers' Compensation would be, because they're going to allow the medical director or the medical providers and experts to make the medical determinations, and they'll make the determinations on the law. The parties can agree on an IME selection and present it to the judge for approval also under this, which should be able to expedite that process, assuming you can find a physician that you all can agree upon. As for limited liability protection, the existing laws cover very limited liability protections over some government employees, healthcare providers, and others who respond to natural or other disasters. The pending House bill will provide similar protections for employers, healthcare workers, traditional and non-traditional healthcare facilities during the COVID-19 health emergency. It's going to provide limitations of liability for damages caused by the use of PPE for anyone who has used, employed, dispensed, or administered personal protective equipment. And you know, the spirit behind these would be that they're trying to, one, get the PPE on the market quickly. Maybe they've short-circuited some of the testing that would have otherwise. They want to provide some sort of limitation of liability there. And with regard to the other, it's just extending the previously announced limitations on healthcare workers to those that may be a little bit non-traditional and have been required as a result of the stress on the healthcare system. It's also providing protections for certain products through the Public Readiness and Emergency Preparedness Act. And that's, again, talking about the PPE. They're extending that to hand sanitizers, disinfecting products, things of that nature. And lastly, there's a proposed bill that will provide liability protection to a restaurant who provides food during declared state of emergency. These will likely require some establishment by those entities that they're complying with the guidelines and restrictions placed upon them. It's unlikely that we're going to see any full-fledged safe harbor for employers or entities from all forms of liability. What's more likely is it's something that looks more like a Good Samaritan law that exists for healthcare workers, in which case measure of liability may be whatever a business is following the published state and federal guidelines at the time. The space and separation, how many people are allowed inside at the time, whether the business enforces face mask protection, etc. Employer and entity just can't willy-nilly open up the doors and say, we can't be sued. Now, as far as moving on to the updated legislation, before I hand it over to Matt to wrap it up, the common areas addressed nationwide through the proposed legislation have been unemployed benefits expansion, inclusion of COVID-19 as an injury illness under workers' comp laws, presumptions of causation for healthcare workers and first responders, extensions, suspensions of legal deadlines, in court cases, whether it's prescription, peremption, statute of limitations, health insurance coverage for COVID-19, and some requirements that employers provide their employees with health insurance coverage during the COVID-19 crisis period. And this is from various different states. This isn't necessarily widespread, but I just found these were all interesting, and particularly for folks who are on this call. Business interruption insurance coverage is something that a lot of states are working on, ensuring that businesses who have business interruption insurance, that COVID-19 will be covered, because it's not under the policies now. The limited liability immunity we talked about, and the use of PPE in social and work settings. So as I indicated before, at least 30 states, the District of Columbia, Guam, and Puerto Rico have introduced legislation related to COVID-19. Some of the Louisiana ones that are relevant are the suspension of legal deadlines, the severance of taxes levied on oil, natural gas, and condensate, suspension of corporate franchise tax levied on domestic and foreign corporations, and the initial tax levied on certain business entities subject to corporate franchise tax. These are all pending. The requirement for healthcare coverage for COVID-19 diagnostic testing. Limited liability requires reporting of contagious or infectious disease to first responders. EMT or firefighter shows up, it provides a requirement on the patient to disclose that information. The things that are referenced here are the things that we talked about previously with regard to the workers' compensation claims filed by essential workers. We still haven't gotten clarification on the mandate as it sits now in the pending legislation. We'll expect to see that back off a little bit, potentially a presumption, but as it's written now, it is a shall be covered under the comp law. So we'll see how that falls. And the last thing before I turn it over to Matt is I saw, in looking through the legislation, a couple of interesting / comical pending and or adopted laws in various states. One is a pending legislation in Missouri that condemns the Communist Party of China for their obfuscation of the truth about the lethality and transmittability of COVID-19, and urges Congress to hold China responsible, and supports the Missouri Attorney General's civil action against China. Another one is Alabama. This has actually been enacted. It urges individuals to fist bump rather than shake hands. The state of Florida, who obviously takes their job very seriously, has declared, and this has been adopted law, has declared Florida State University Seminoles basketball team, by virtue of tremendous skill on the court and the heart and spirit shown by the players and coaches this basketball season, the 2020 NCAA basketball champions by default upon cancellation of the NCAA tournament due to concerns raised by the spread of the novel coronavirus COVID-19. So they're clearly focused on the work that needs to be done here. And lastly is in New Jersey, it is a pending legislation that establishes second degree crime for making credible threat to infect another with COVID-19 or similar infectious disease that triggered public emergency. This tracks some of the terror legislation that's out there. So those are some interesting things, some that are comical, and hopefully some information that's useful to you. With that, I'm going to turn it over to my partner, Matt Crumhorn, who's going to wrap us up.
Thank you, guys. I appreciate it. Thank y'all for taking the majority of the time, too. That was a big help for me. I appreciate that. My job today was to kind of follow up on state workers' compensation in Louisiana. We've had 2 previous webinars and have really gone through the state system pretty thoroughly as far as payment of SEB benefits for people working modified duty and what to do, whether they're working full-time or part-time, or earning their wages or not earning their wages. And any one of us are happy to go through those if anybody wants to pull us aside and have a conversation about specific cases. I do want to point out in the short period of time we have left, the three bills that were enacted or at least discussed by the House, one, the vocational rehabilitation services. It's interesting that they're going to try to propose a law to allow there to be a dispute between an employer and employees' voc rehab counselors. I think it's going to create an enormous amount of litigation. You're going to have situations where the voc rehab counselor for the employer is finding jobs within a medium to light duty position, and the claimant's voc rehab counselor is looking for a job within a sedentary to light duty position, and you have this battle about what jobs are appropriate, which voc rehab counselor is considered the better expert because that's what they are. It is going to create an enormous amount of litigation on that specific issue alone. Kind of the same thing with the IME. I agree with Chad. I think it's fantastic if the state medical director gets out of the IME business altogether, and leaves it up to the courts. Right now, a workers' compensation judge can appoint a third doctor for any reason they want: causation, compensability, discussion of certain body parts. And under the current law, a medical director cannot do that. They can only do it under medical condition and disability. So if you have an issue about whether a lumbar spine injury is causally related or not, you can't get that resolved under the state system. It has to be in litigation in order to address that with the courts. What we have been doing is we've been trying to push it into litigation and also file an IME at the same time to try to put that issue, a causation issue, in front of a judge. Sometimes they're kicked out. There are certain requirements for when an employer can file a 1008. Most of the time, you have to cut somebody off or allege fraud in order for an employer to file a 1008. And you got to kind of force an injured worker to do it. With this particular situation, if this bill is enacted, it will give the employer another option to file a 1008 on its own without having to modify somebody's benefits. In regards to the bill that was talked about previously, giving a presumption of compensability for essential workers on COVID-19, that is happening all over the country. The governor of Kentucky talked about instituting a presumption bill that basically says if you're an essential worker and you contract COVID-19, it is presumed it happened in the course of your employment. Illinois tried to do one. Kentucky, Illinois, Florida, California, Louisiana has had it. None of those bills are going anywhere. There are both, obviously, there are both legal and practical concerns about instituting that presumption in this scenario. So I agree with Chad. I don't think anything really is going to happen on that front. It's going to be on a case-by-case basis. Certainly, if you have hospital cases, if you represent a hospital and somebody develops COVID-19, I would not want to take that case to trial on a denial. I think you're gonna lose on that case in front of a court. Now, somebody in a law firm like myself or Chad who contracts COVID-19, that's a good denied case. I don't know how I could prove that I developed this sitting in my office, at a law firm. So I think you're going to have to take them case by case. The way the comp system's set up right now is we learned last week that all of the comp courts are slowly coming back into the office. Right now, they're having 2 people in the office every day. The judges are working in the office 2 days per week. The workers' compensation mediators, every district, there's 9 districts in Louisiana, every district has a staff attorney that serves as a mediator. Every one of those mediators were given government-issued cell phones. They are allowed to use their cell phones to conduct mediations at their house. I had 2 this morning. They're participating just like a regular mediation. Everybody's kind of calling in and they're just doing it by phone. But what the mediators are telling me is when everything gets back up and running, all of the cases that are pending for trials, they're going to get pushed to a mediation. If you have a case right now, let's say that's set for trial on May 30th, but the injured worker is getting paid medical and indemnity benefits, and the issue for trial is a limited issue and doesn't necessarily impact a person's right to benefits or their current payment of benefits, you're probably going to get it continued and pushed to a mediation. The docket is going to be so chaotic and so large that the cases that are going to go to trial are the cases that are completely denied cases. The guy's not getting paid any indemnity benefits. They're not receiving any medical treatment, and they need a decision on their claim immediately. Those are the cases that are going to get tried. Any other case, I would not be surprised if you get a ex parte continuance from the court and you get an order setting a mediation with the workers' compensation mediator. That being said, now is a good time to settle your cases. We are all getting settlement offers from plaintiff attorneys. People are looking for money. The workers' compensation judges are signing the settlements within 24 hours. They are pushing to resolve some of these cases. Now is a good time to do so. So if you have any cases that are in that, that are ripe for settlement, or you have someone that's at maximum medical improvement and you've been going round and round and round about voc rehab and you can't find a guy a job and they don't want to participate, now's your time to settle your case. Because IMEs, trial dates, pending discovery, that's going to be a mess in the next 30 to 45 days when everything starts getting put back on the docket and you're trying to figure out where your case stands, either with the medical director as far as IMEs or getting surgeries approved, or finding your trial date. And where's my trial date going to be? Am I going to be in June? Am I going to be in July? Am I going to be kicked off altogether? So I would recommend to everyone, find those cases that can settle and let's get them done and get them closed, because it is very easy to do so nowadays. There was a case that was talked about last time, a federal court case, our last webinar, about participating in depositions via Zoom. We strongly encourage that everybody continue to do depositions via Zoom. The Eastern District of Louisiana issued a ruling that there can't really be any objections between the parties about the admissibility or authenticity of a deposition, as long as a court reporter can see and hear the deponent and administer the oath. That is classified, that is going to be deemed a valid deposition testimony. So as we slowly move back into to normal regular work schedule, the Zoom hearings, the Zoom depositions, we continue to try to use those. And it's just going to continue to move your case forward despite all these delays we have. But everybody look at their dockets and look at their calendar. If you have a trial date in May or June, I would think about pulling that case and doing a reserve allocation or doing some sort of review and see if you can put some money on the file to try to settle it. I think that will ease everybody's burden down the road as we get back into this. And that's pretty much all I have. I thank everybody for being here today. Gabe, Chad, y'all have anything?
Nope. That's all I've got.
No, we just need everyone that has attended today to go ahead and email John Rabelais your state that you are licensed in with the licensing number for continuing education credit for adjusters. We have it for Texas, Louisiana, Florida, and was there another one?
Alabama.
In Alabama.
Thank y'all very much. Y'all have a good week.
Thank y'all.